May it please the court. Mr. Brown, with all due respect to Judge Overman in this matter, her ruling needs to be reversed. I'm not sufficiently glib enough to say this any other way, except I don't believe the Iowa law is as ineffectual, irresponsible, or indifferent to the public safety as the effects of this ruling would suggest. Let's consider its ramifications just for a second, if we might, please. Assume you have a DOT motor vehicle enforcement officer on patrol going northbound up Interstate 35 at the time applicable to this case. And we know from the record in this case that officer is a trained, certified peace officer. The officer has peace officer status conferred upon that officer under Iowa Code Section 801.4. Let's assume that officer, as the officer is patrolling and going northbound, looks in the rearview mirror and notices a vehicle coming up from behind at a very rapid rate of speed on the interstate. The vehicle closes in on the DOT squad car, zooms around to the left, going by the DOT squad car, at which time the officer activates the radar unit in the vehicle and gets a clock of 105 miles per hour as that car zooms north on Interstate 35. Now, under the ruling issued in this matter by the district court, that DOT officer is without authority to chase that vehicle down, bring it to a stop, arrest, or even cite that violator for what was going on. That turns the Iowa law on its head in terms of the ability to make an arrest with respect to an offense committed in the presence of another. It turns on its head this court's holding in State v. Moore, where this court said that Iowa Code Section 321.285, Iowa's speed law, confers upon peace officers both a public safety and a law enforcement function. The public safety function, it seems to me, goes out the window. In fact, irony of ironies, as I understand the situation here, in the aftermath of this ruling, the officer's only recourse apparently is to call for the police, but the officer is the police. And perhaps if the officer is so inclined, engage in prayer in the hopes that that person going 105 miles per hour up the road doesn't crash into somebody, killing somebody. Now, the basic problem, it seems to me, and the confusion that we're having here in this case stems from this rigid reliance upon this Merchant's Motor case from 1948. It is as if the law was frozen in time in 1948, and in the ensuing 70 years, there have been no developments, nothing in the law that might alter the analysis. I'm here to report and submit that I believe there's several material things that alter the analysis. First and foremost, district court hinges her entire ruling upon Merchant's Motor. Remember, at the time Merchant's Motor was decided in 1948, the DOT wasn't even in existence then. It was about 26, 27 years before DOT was created. You had the Iowa State Highway Commission. The commission employees were just that. They were employees of the Highway Commission. They were not peace officers. So in that case, you have the Supreme Court being presented with an argument by the Highway Commission that those employees ought to be able to stop those Minnesota trucks crossing the border into Iowa, for which Iowa was claiming they were violating our registration laws, because Iowa Code Section 321.492, relevant portion of which reads pretty much the same today, says that a peace officer may serve a summons of a traffic violation and may also stop a vehicle to do a registration certificate inspection. And this court in 1948 said, well, that's true, the statute does say that. But the fallacy in your argument, Highway Commission, lies with the fact that your employees are not peace officers. So here's one big difference right off the bat. As of the mid-70s going forward, after the creation of the DOT, these folks get peace officer status under 801.4.
Let me interrupt your argument
Sure.
a little bit, Mr. All right. I mean, I agree Merchant's Motor is an older case, but the statutes until 2017 hadn't really changed. And didn't Merchants Motor rely on 8022 that is part of the DPS authority and says other agencies of the state may not exercise authorities that are given to the DPS by, and then they cite something, and the something they cite is in 321, and it's the authority that DPS has to basically enforce traffic laws. So, I mean, it's not like we made this decision. I mean, you can criticize the policy, but it sounds like the legislature made it, didn't they?
Well, there's been some changes in the law since that time, Justice Mansfield, that I think need to be pointed out. And the court in Merchants Motor did cite to 80.22. But also, what's so significant about Merchants Motor is the fact that these folks aren't peace officers at that time. When they say to the Highway Commission, the fallacy in your argument lies with the fact that your employees aren't peace officers, transpose what happened in the 70s back to that legal landscape in 1948, and the court can't make that statement. And the peace officer's status, I think, is significant in several respects, which I can illustrate to you. In fact, Judge Grady, in the Werner case, which was submitted non-orally earlier here this afternoon, of course, finds authority officially for the DOT officers to stop vehicles for speeding, and also alternatively agrees that the Citizens Arrest Authority and State v. Lloyd applies as well. But I think he's on to something, at least in this respect. Merchants Motor was decided at a time when the legal landscape assessed an environment that did not involve peace officers. So what happens when you come forward into this era, into the 21st century at least, with respect to the ruling that Judge Overham issued? When you rely upon Merchants Motor as really your sole authority for this, here's what happens. You get strange results that do not apply to the modern day law, and I'll use the school bus safety scenario as one example. We have on the books some laws that are intended to protect school children when they get on and off their school buses. And we had a tragic accident in this state about 7 years ago up near Kensett in Worth County, where a little girl named Cady was struck while trying to board her school bus by somebody that illegally passed the bus. The bus had the stop arm out, and the driver hit that little girl, fled the scene. There was an outcry afterwards for tougher penalties, tougher driver's license sanctions, tougher criminal penalties. The legislature responded and enacted these laws, sometimes referred to as Caden's Law. Now take a look at 321.380 of the Iowa Code. It says that it is the duty of the State Patrol and all peace officers to enforce those provisions. Yet if you rely rigidly, as the district court did, upon this Merchants Motor case, here's what you get. You get the district court saying, well, wait a minute, in 1948, everything had to be boiled down to operating authority, registration, size, weight, or load, and if you're beyond that, you don't have authority. Well, how does that account for the modern-day peace officer status in 321.380, where it says all peace officers? All peace officers, in my estimation, is a fairly inclusive term. That's pretty global. All peace officers ought to include the DOT peace officers.
I mean, Merchants Motor, wasn't it kind of reaffirmed in A1 disposal? Didn't we?
No.
I mean, that was an issue there where there was a question. DOT was performing stops and inspections at a temporary checkpoint. There was a constitutional challenge. And in the course of rejecting the constitutional challenge, our court said, well, don't worry about it because DOT's power to intrude on individuals is strictly limited by the Iowa Code to inspecting for registration, weight, size, load, and safety violations. In other words, that was clearly a basis for our holding in 1987, upholding that stop, saying, yeah, this is all they can do, and we cited again those same code provisions that are at issue here.
Well, I don't think that's all they can do. There's more to that. I think the court relied upon 321.492 in part. I don't think Merchants Motor was even referenced in the opinion. So I wouldn't read A1 disposal as any great ratification of Merchants Motor. And moreover,
why couldn't the legislature just, when they amended or when they made these people police officers and started, take the provision out that limited their authority?
Legislature could do what it wants. For example, with respect to
They didn't do it. They didn't take it out. And if they would have taken it out, it would have been clear they have authority to write tickets.
Well, they have authority to write tickets anyway under the citizen's arrest provisions that are in Iowa Code Section 804.9.
Under a citizen's arrest, though, you have to call another officer to issue the ticket. You can't just issue the ticket. I mean, I could do a citizen's arrest and write out a ticket and give it to him.
Oh, now that's part of the fallacy, I think, that the district court. Let me expand on that, Justice Wiggins, because I think that's a good question to buttress our argument here. That's part of the problem with Merchant's Motor. It is an outmoded analysis of the citizen's arrest doctrine. It took what you just said. It said that, well, we recognize the Highway Commission employees could make a citizen's arrest, but they can't do so here because they acted officially. They were acting in their official capacity, and they're issuing summonses which a private person wouldn't be allowed to do.
But in the Lloyd case, when the officer came over from South Dakota, he had to call an Iowa officer to issue the ticket.
No, he did not. He was commended for calling in another officer for the OWI charge. He issued a ticket in Lloyd.
But it was a South Dakota ticket. He ticketed him for what he was doing in South Dakota, not what he was doing in Iowa.
Yes, he ticketed him in Sioux City, Iowa for something going on in South Dakota.
But it's, that's not authority for. He didn't need the authority of Iowa law to do that.
Oh, he certainly did. It seems to me there's nothing validating that stop. When he crossed the border and came into Iowa, he had no more peace officer authority than I do, you do, or my granddaughters do. That only thing validating Officer Sandage's authority in that State v. Lloyd case was the citizen's arrest doctrine.
But let me follow up on Justice Wiggins' point. It does seem to me it's kind of inconsistent to say, on the one hand, DOT is exercising citizen's arrest authority as provided in 804. On the other hand, they're issuing citations which citizens can't do. I mean, it seems to me if you can only do one or the other. You can't claim you're a private person and a peace officer for one and the same activity, right?
No, not at all. I don't read State v. Lloyd that way, Justice Mansfield. State v. Lloyd makes it clear that a peace officer, even if the officer has to rely upon citizen's arrest authority in 804.9, doesn't have to act like a private person. The officer continues to have indicia of authority in office. They may write a citation. They don't have to take a person and formally arrest them, take them down for a traffic charge, and make them sit in jail awaiting appearance before a magistrate. They may use the citation process in Chapter 805. Lloyd discussed that. Moreover, you have an amalgam of statutes in there that indicate the DOT has a vital interest in seeing the enforcement of these Chapter 321 provisions. I'll grant you they kind of grow up, as Justice Wiggins alluded to, in a kind of a patchwork quilt fashion over the years. But if you take, for example, a look at Iowa Code Section 321.3, which says that the director of that agency is vested with the power and charged with the duty of administering the Chapter 321 provisions, that alone indicates there's a vital interest on the DOT's part in making sure these rules of the road violations are acted upon.
So we just write out the statute that limits their ability to do things.
Doesn't write out the statute at all, Justice Wiggins. It just means that they have a separate statutory authority under Iowa Code Section 804.9, which this state has a very robust citizen's arrest doctrine.
That statute has no force in effect in Iowa because, under your theory, they have authority to do anything a peace officer can do.
They have the authority. No, they don't have the authority to do anything a peace officer can do. A peace officer has general arrest powers. They can make arrests for burglary, what have you. They have the authority under 804.9 to act when an offense is committed in their presence. If you don't have that, go back to this school bus scenario. Under the district court's rationale here, when everything's related to operating authority, registration, size, weight, and load, let's go to the present day. Let's say we have another tragic occurrence.
That's a specific statute giving him jurisdiction under the statute that created the crime.
There's two grounds of authority there. Let me give you a hypothetical. If we go to the present day and we have a DOT squad car in a line of traffic behind a school bus, the same thing happens as happened with Cady, where somebody jumps the line, runs into a little boy or little girl, and flees the scene. One, I believe that officer has statutory authority because the officer falls within the meaning of all peace officers in 321.380. And two, even if the officer is lacking there, as they contend he lacks that. Even if that's the case, that officer has observed public offenses committed in the officer's presence. It's frankly ludicrous to think that our law has been rendered so ineffectual and so irrelevant that a certified peace officer, having observed that kind of an occurrence with a little boy or a little girl, has no authority to pursue that violator, put the person under arrest, and charge them. I see my time has expired, and I'll come back on the rebuttal. Thank you so much.
Mr. Formaker, thank you as well. Mr. Brown.
Thank you, Your Honor. May it please the court, counsel. Good afternoon. My name is Brandon Brown. I have the privilege of representing the petitioner Appellees in this case, and I think I'm going to jump right into discussing this distinction that the DOT is trying to make between what happened in 1948 in Merchants Motors and what justifies their behavior now. And that is they're hinging their argument on this distinction between the highway commission employee and them being peace officers now. But it's very important to look at how the DOT are or is defined as a peace officer, and that's in Iowa Code Section 801.4 sub 11 sub H. And they're defined as peace officers insofar as they have authority, specifically mentioned 321.477, which takes us back to the Merchants Motor analysis, where they said the Highway Commission employees are restricted in their enforcement abilities based on that same statute. Now, back then, the statute didn't include registration, and that's what Merchants Motors was challenging, was the tickets they were receiving for the registration. And perhaps that case was a precipitating event that led to the legislature then adding registration in as one of the enforcement abilities under 321.477. Nothing else substantively has changed at all since Merchants Motors. So what we have here is, for about 70 years, this court interpreting the DOT's enforcement authority, and from what the record bears out, which is on page 237 of our appendix, since the creation of the Department of Transportation in 1974, the DOT has been systematically issuing tickets to motorists, tens of thousands, and if you extrapolate it out over the decades, hundreds of thousands of tickets in violation of this court's holding in Merchants Motors, as well as in violation of the statutory limited authority that they have under 321.477. I think it would.
What do you do with, Mr. Formaker mentioned the Moore case, and we did say in Moore that involved a stop performed by DNR in a state park, and we did say that Iowa Code Section 321.285 confers a public safety function on Iowa peace officers as well as a law enforcement function. And what were we meaning there? What were we trying to say there?
That statute was also referenced in relation to Iowa Code Section 456A.13, which, if you look at that section, Your Honor, it indicates under the DNR that they have the same powers, and this is the legislature saying it, they have the same powers conferred by peace officers in the enforcement of the state law. So I would argue that they are more aligned with the Department of Public Safety in terms of general enforcement authority, rather than with the DOT on limited enforcement authority.
Perhaps only if it's in a state park.
Perhaps, and I think, if I recall correctly, that's where more occurred. And the other thing is, if you look at, I think it's 321.42, it indicates it's a simple misdemeanor for a person to do an act forbidden or fail to perform an act required. So I think that's where it comes into play. But the bottom line is, the DNR has the statutory authority to issue those arrests and engage in that function, unlike the DOT. I think it's important also to put this citizen's arrest argument in context. And we have the opportunity to do that through open records requests, which we've included in the appendix. In terms of reference, the first domino in this case or on this issue occurred around October of 2016, where the trial court decided that the DOT doesn't have general enforcement authority and struck down a speeding ticket that was issued to a young man in Polk County. And if you look at page 229 of the record, there was an email, and that email came from the now director to the former director. And it was 2.5 years even before the Polk County case was decided. And in that email, it specifically discussed the enforcement authority the DOT has. Apparently, there must have been some issue because Mr. Lowe indicated that this section 477 has always been a source of claim that the MVE should be restricted. And what we find out by reviewing, and I'm not going to go through it in detail, there's no mention of citizen's arrest in that argument. In fact, what they hang their hat on is a definition of peace officer, which is what they're trying to do today. And then, approximately 2 months before the Polk County decision comes out, the media sends a request to the DOT asking them, hey, what is your authority to issue these speeding tickets? And they list out several different statutes, including 321, 477. They refer to the peace officer statute, which, as we know, relates back to their limited authority. But nowhere, again, do they reference citizen's arrest or State versus Lloyd. That argument only came up in the wake of...
I mean, but everybody comes up, litigants, us, comes up with ideas as things are litigated. I guess, I mean, I'm more interested in why can't they be a private person? Why would they have less authority than a citizen to make an arrest?
Well,
than
I
a
don't know if
private
they...
citizen?
I wouldn't necessarily say they have less authority than a private citizen. They're just operating under different authority, and that's because, as I think you pointed out, Justice Mansfield, in some question and answers, these agencies, they operate by statute, and only as much as the legislation provides them. And Iowa Code Section 80.22 confers the Department of Public Safety traffic enforcement authority. So if you allow the Department of Transportation to implement a policy, which they have, we have that in the record through an exhibit and through sworn trial testimony from a motor vehicle enforcement officer, what they're doing is they're conferring on their officers police power that's not granted to them by the legislature. If they want that authority, they can go across the street and ask for it, which is what they've done. And it looks like that's what they've done in the wake of Merchants Motors, is they got the law changed. But they shouldn't be coming in here to this court asking you now to justify their behavior under a citizen's arrest statute when they're not even engaging properly in executing a citizen's arrest, even if they did have the authority to do it.
Find that they might have citizen's arrest authority but not citation authority at the same time.
Well, they certainly cannot implement a policy because that would violate Iowa Code Section 80.22. And I'm talking historically now because the law has changed dramatically since these cases have been decided. I believe the DOT would have to show, and again, if you got past the official policy, they'd still have to show that they're complying with both provisions of citizen's arrest, which would be 804.9 and 804.24, because you have to read them in conjunction with each other, and you have to give them both effect. The first statute says when you can effectuate a citizen's arrest, when an offense occurs in your presence, but then the second, what you must do to properly effect the arrest, and must is mandatory. It's not permissive. So the DOT will have to historically go back and show that they either took the motorist without unreasonable delay before a magistrate, or they must show that they, without unreasonable delay, summoned a police officer and then accompanied that police officer in front of a magistrate. And that will be easy to decide because if they're all uniform citation and complaint charges, then they didn't comply with the second most important component of the citizen's arrest statute.
Mr. Brown, what's your response to Mr. Formaker's claim that the oddity that you could make a citizen's arrest and a DOT officer could not?
Well, first of all, they would be operating under official policy because that's what the record establishes, and that's what 80.22 in the legislature prohibits. And they haven't done it correctly, is the other answer. They haven't complied with 804.24. Now, and the other thing is, they have the technology and the trappings of law enforcement. I think even Lloyd recognizes in the Lars case from Illinois, people like me, we don't typically have radar detecting equipment in our vehicles. So we have state actors, and there's an extreme example about somebody going 105 miles an hour, but what about somebody going 72 miles an hour in a 70? Let's be honest, what are they looking at? They're looking at their speed detecting equipment, which is issued to them in their police car, where they're operating on the state's dime. They're using that vehicle to engage overhead lights, pull somebody over, walk up to them with their state-issued uniform, their sidearm and their taser. They investigate, they run the license on their state computers, and then they go issue a citation that I don't have the authority to do. So if they're going to operate in that function, then they don't get the benefits of a arrest by private persons, because there's no peace officer exception there. If they want to stop somebody without using the accoutrements of their office, and they want to properly engage the citizen's arrest provisions by contacting without unreasonable delay a peace officer and accompanying that person to a magistrate, or take him directly to the magistrate, then I guess they do and would have the same benefits as me as a private person. But they're not doing that.
So they'd be like off-duty? Is that what you mean?
Perhaps they could even do it on duty. Well, it depends on how they use it. I mean, yeah, off-duty would be would be optimal, but I mean, if they're using overhead lights and they're using the instrumentalities of their office, then it's certainly problematic to me. And if you look at other states, the Lars decision, that's where they draw the line. If you're using instrumentalities that are not available to a private person, then you're not a private person. You're a peace officer, and you must function under the arrest provisions of a peace officer. And in terms of Lloyd, I think that it's important to note, first of all, it's not even close to being on point as Merchants Motors is, but Lloyd involved a police officer who actually had the authority before coming across state lines to issue these citations. I think, Justice Mansfield, you correctly pointed out, there's nothing in the record to suggest that those were Iowa citations, and there was nothing in the record to even suggest that those citations were taken up on appeal. They're just merely referenced in there. The issue that was taken up on appeal was obtaining the intoxication information through the Iowa the Iowa law enforcement's investigation. So they were, and I know that the Lloyd court didn't make a distinction between a formal arrest and detaining, but that was in the context of 804.9. But I do think there is an important distinction here between detaining and arresting, because in most of the cases, if not all of the cases, with the exception of Headland, the DOT or the officers that the DOT cites in their opinions, they were all involved early on. And then a police officer came and assumed the investigation. So perhaps individuals have the ability to detain for a temporary period of time if you are going to begin the private person's arrest provision. But once you pass it over and the actual peace officer arrest, then I don't think that really constitutes a citizen's arrest. That's more of just holding somebody for an officer.
How does the 2017 amendment guide us? I mean, on the one hand, we assume amendments are made for a reason. They change the law. On the other hand, the state argues that just clarified in view of the dispute. Which way should we use it?
Well, I would urge the court to adopt what the district court says. Anytime there is a substantial amendment, it indicates there's a change in the law. And that's what we have here. But that is more of an expanding the limited enforcement authority. The state's conceded, or excuse me, the DOT's conceded. They only have their DOT authority for enforcement under 321-477. What we're dealing here is their citizen's arrest argument. So as far as the legislation, it just perhaps shows the proper channels to go through if you want to expand your authority, and you shouldn't be relying on a citizen's arrest Hail Mary pass to validate 40 years of past illegal behavior.
Has there been has a class been certified for refunds to all the people that have these tickets?
So here's where we are on that. We have filed a petition at law, and we have named a putative class. We haven't certified because the court found that we hadn't exhausted our administrative remedies, despite our argument that it would have been immaterial because the DOT had effectively said they're not going to change their mind. but so the court, what the court did is it stayed that case. It allowed us to apply for a declaratory order. That was denied. We went on judicial review, so we're still stayed pending the ruling from this court.
What we decide in this case doesn't address that remedy, correct?
Correct. That is correct. I see my time is almost up here, and I'm afraid if I start, I'm going to keep going. So unless I have any other questions, I'm going to just ask the court to affirm the district court's ruling. Thanks.
I do have a question before you go.
Okay.
Sorry. I read somewhere, and maybe you can correct me if I'm wrong, was there some sort of policy, and if so, at what stage of this timing, that DOT would pull people over if maybe more than 25 miles an hour?
Great question. In fact, in the record, I have the memorandum. It's undated, but if you take that and compare it to the sworn testimony that's in the record from Officer Witowski from the State versus Atson case, I believe Officer Witowski said for at least 2 years prior to that case, which would have been back in 2016, there was really no restrictions on speed limits or how far in excess you must be, and before that, they had to be going a certain speed, perhaps like 25 over. So, and again, we were in the declaratory or in our civil petition with state, so we haven't gotten into the discovery process. This is information we've only been able to gather through open records. Thank you.
Thank you, Mr. Brown. Rebuttal?
Thank you. Couple points. First, State versus Lloyd makes it very clear, and it cites to the Restatement Second of Torts, Section 121, Comment D, that says it doesn't matter in making an arrest whether a peace officer purports to act officially or otherwise. All these arguments are a rehash from Merchant's Motor that were rejected in Lloyd, meaning that if the officer is going to make an arrest, the officer's got to get out of the squad car, can't flash the lights above, can't run the siren. That's rejected in Lloyd. Read that opinion. I don't see how you can come away with thinking that that's viable. Use my hypothetical at the start. The DOT peace officer has observed a violator at 105 miles per hour going by that officer on Interstate 35. After Lloyd, which notes that the officer does not lose the indicia of authority in making a citizen's arrest, that officer is not constrained in pursuing that violator by not going over the speed limit. That'd be an absurdity, quite frankly. And that's what Lloyd was getting at. In fact, they made the statement that we understand the symmetry of the argument where you say, well, if you're going to act like if you're going to make a private person arrest under citizen's arrest, you have to act like a private person. Not so if you're a peace officer, and that's a significant distinction right there.
In Lloyd, didn't we say this? Isn't this sort of an essential part of the reasoning? When we quoted that earlier case involving the Nebraska officers, and we said when the Omaha officers came to Iowa, they ceased to be officers, but they did not cease to be persons. So wasn't it sort of an essential part of that once this South Dakota officer crossed into Iowa, he was, for all intents and purposes, a private person, unlike
yes.
a DOT employee.
And if you accept the Attorney General's opinion from 1990, which DOT has accepted the advice and acted consistent with that there are not general arrest powers conferred on these officers, that's a limitation on their designation. And like that South Dakota officer coming into Iowa, if they act on offenses that are outside their designation under the citizen's arrest statute, that's the same thing. That's why Lloyd really answers this quite nicely, I believe. Moreover, think about this. There's something peculiar here with this ruling, too. The district court, as I read it, embraces this portion of the Attorney General's opinion from 1990 that told DOT, in answer to a question about whether or not DOT officers could make arrests for drunk driving, she seems to embrace that. The answer in that opinion was on two grounds. The Attorney General said, yes, DOT officers can make arrests for drunk driving. Now, that's not in 321-477. The Attorney General said there were two separate grounds of authority that support that. One, if they have the training that's talked about in 321J.1, then yes, they're a peace officer under that provision. But moreover, meaning in addition to that, even if they don't have that training, If the offense occurs in their presence during their normal activities, while they're on patrol and they witness this offense, they may act under the citizen's arrest powers. Not binding on you, but the district court takes that and kind of inverts it and says, well, there's one crime that citizen's arrest can be invoked by a DOT officer, and that's OWI. It clarified, but it also made a substantial change. They've got far more general arrest powers than they had before. It did both. It also ratifies the position we're taking because they continue not to have general arrest powers under certain circumstances in cities. Yet in that amendment, the legislature, if they were so upset about the use of citizen's arrest, preserved it, saying that nothing herein shall be construed as a limitation on the power to act upon offenses committed in the officer's presence. That's a ratification of the doctrine. In the few seconds I have left, let me go back to a question you asked, Justice Mansfield, about the citations. Because if you read State v. Lloyd, I don't know whether they may have been South Dakota citations, but the court spends a lot of time on page 743 in volume 513 Northwest 2nd talking about citation in lieu of arrest under Chapter 805 and talks about all the Iowa Code sections that encourage the use of citation. Now, I don't think the court would have spent its time doing that if it didn't think in the course of a citizen's arrest by an Iowa peace officer that the citation process couldn't be used. I think that clearly indicates that. There's no need to take the person down before a magistrate when we have statutes on the books saying a peace officer who doesn't lose the indicia of authority when the officer makes citizen's arrest may issue a citation. As long as the person signs the promise to appear, they're free to go. They don't have to go to jail and await pretrial release with an appearance before a magistrate. I see I'm out of time, but I ask you respectfully to reverse Judge Overham and reinstate the declaratory orders that were issued by the DOT by Mr. Lowett's director. Thank you.
Mr. Formaker, thank you as well. And Mr. Brown, thank you again. The case is now submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.